Thank you. Be seated, please. All right, we're back on record. State versus Alan Shoemaker. Now, ladies and gentlemen, jury service may be strange to some of you, so a short explanation is in order. Those who participate in a trial must do so in accordance with established rules. That's true of witnesses, the lawyers, the parties, and the judge. It's also true of jurors. The lawyer for the state, and Mr. Shoemaker, will present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted and what proposed evidence will be excluded. Now, you as the jurors will be the sole judges of the facts, credibility of the witnesses, and the weight to be given to the testimony and the evidence. And the court will later instruct you regarding the law on those issues, and you will apply that law to the facts in your deliberations. Now, as jurors, it's your sworn duty to accept the law is given to you by the court. Now, procedure for the trial will be as follows. First, each party will outline what they expect the evidence will be. Now, these are called opening statements. Opening statements are not argument, they're not evidence. They are simply a preview or outline, if you will, of the claims of each party and are designed to help you follow the evidence as it's presented during the trial. After opening statements, then the state will offer evidence. And then after the state completes its evidence, the defendant is not required to, but may offer evidence. If the defendant does offer evidence, then the state may, but is not required to present rebuttal evidence. And after that, the court will give you the instructions of law. There will be closing arguments, and then you'll be given the final instructions on how to deliberate return verdicts. And then 12 of you will then deliberate on your verdict. Now, the procedure for questioning witnesses is as follows. The party that calls a witness will ask questions first. That's called the direct examination, or direct for short. The opposing party will then ask questions, and that is called cross-examination, or cross for short. And then the party that called the witness may ask questions about only those matters that were testified to on cross-examination. And that's called redirect examination, or redirect for short. Jurors are not permitted to ask questions in case that might occur to you. Now, during the trial, it's likely that an objection will be made. You already heard one during the voir dire. That is the procedure by which a legal issue is raised that the judge must determine. And I don't just do that based on what I think is right or wrong. I have the rules that I have to follow, statutes and rules prescribed by the Supreme Court, and I interpret the objections based upon those initial rulings. Now, if I say that the objection is sustained, that means that the court's determined that the question and or the proposed answer are not proper evidence and may not be admitted. If I say overruled, then I've determined that both the question and the proposed answer are admissible and can be heard. Now, sometimes in a trial, actually almost every trial I've ever been involved in, an objection is made while the witness is answering the question, and before the court has an opportunity to make a ruling. Now, if that happens, and I determine, if I say it's overruled, that means it was okay. Obviously, you can hear it. But if I say it was sustained, then you will be instructed at the end of the case, and maybe at that time, if it's requested, that testimony is stricken. And what that means is that even though you heard it, you can't consider it. So, now again, we know you're not computers, you can just wipe your memory clean, but the way that works is that during deliberations, a juror says, well, remember what that one answer was that was stricken. You say, well, wait a minute, we can't consider that. And that's the way that works. Now, it's important that you be fair and attentive during the trial. As I indicated to you before the break, you're not permitted to discuss the matter with anyone else or even among yourselves. So if you are a person of text or tweets or other social media, don't do anything don't put anything in any of your social media while you're a juror during this case. You're not to discuss it with anyone in person or by phone. You're not to form any opinion or express any opinion until the case is finally submitted to you. And it may be a little difficult to understand, well, why can't we talk about it during breaks? Well, first of all, during breaks, 12 of you may be all together in the jury room when you've all reported back. Some of you may be somewhere else. And any deliberations has to be by all 12 jurors. Furthermore, until you've heard everything that's involved in the case, you don't have everything that you need as a juror to perform your duty. And so, even though you have impressions of a person when they testify, you can't make any decision then until all of the evidence is in, because and may end up changing your mind. Something else will come along, or you will hear something and think one thing. Once you've heard the law, you may say, "Oh, okay, then I've got a different opinion." So we don't want you making any firm, decisions or thinking about making those decisions until the end of the case, when you've heard everything that you're supposed to: opening statements, evidence, closing arguments, instructions of the court. Now, during the break, if we go through lunch, you're at lunch, or any other breaks, again, if you talk to somebody on the phone, again, and they ask you about it, you need to explain to them, I can't do that. Now, once the trial's over, and your jury service in this case is completed, at that time you'll be released from that obligation, and you may discuss it if you wish. You don't have to, but you may discuss it with anyone that was involved or anyone else. Now, no one is permitted to approach you or to talk to you about the matter. Unfortunately, sometimes when people go out and about during lunchtime or in the courthouse during breaks, there may be somebody make a statement that you overhear that they didn't mean for you to hear, and you didn't mean to hear, but you did. Something like that happens. Report it to the bailiff, and then the bailiff will report it to me, and I'll discuss it with the parties and decide whether or not we need to speak with you further about that to determine, what it was and what effect, if any, it would have upon your continued service as a juror. Now, one of the things I want to tell you is, don't say anything to any of the other jurors. If that's something like that happens, talk to the bailiff. And I bring that up because 25, 30 years ago, when I was a prosecutor, we had a trial that lasted 3 days. It was in the wintertime, as I recall. And we had a couple of jurors that crossed the old McGee's. And there were some people in there talking very loudly. And one of the jurors was there, and one of the attorneys was there, and the attorney heard it. Well, the juror went back to the jury room, and there were 3 alternates in that case because it was a longer trial, 15 people total. And they said, hey, at lunchtime at McGee's, so-and-so said blah, 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 blah. And all 15 jurors now know about it. So we spent about 2 hours that afternoon asking every juror what it was they had heard, what they understood, and what effect it had on anything. None of the jurors ended up getting excused. But it took 2 hours out of a 3-day trial on that. So again, don't say anything to anyone else. If there's any doubt in your mind, say it to the bailiff, and then we'll discuss it. You're not permitted to investigate or attempt to obtain any additional information on this case outside the courtroom. It's highly improper for any of you to do so or to attempt to do so. Now, and it was brought up about doing tests and so forth. But that also most often happens, in my experience, during breaks, maybe overnight. We're not going to be overnight in this case. People hear about something and trying to think, well, back in my day, they'd look it up in the encyclopedia. Well, now you look it up online. The internet has everything, right and wrong. I think more wrong than right anymore, but anyway, people will look things up. Well, it's natural to be curious, about something. You say, well, I heard, this thing came up, and I'm wondering about that, and I think I'll find out more about it. Can't do that during the trial because you're getting other information that you're not supposed to have. Once the trial's over, you can research it to your heart's content, but during the trial, don't do that. Now, I'm sure we're not going to make the paper or the radio or TV, but also, today's concern is more about social media, because people can post something, almost as it happens. So For that reason, you're not to read, view, or listen to any kind of a report or article or communication in any media form, newspaper, radio, television, internet, social media, regarding the trial or any subject of this trial. And again, if you're checking on your social media accounts during breaks, don't permit anyone to comment about your being on, read any comments. Don't make any comments about your service as a juror in this case, because the law requires that you consider the case and decide it solely on the evidence in the case submitted and the instructions of the court, and anything else would be improper. Since this trial is going to be fairly short, I don't permit note-taking. I give you the example that I've given for years. I was 18 years old, went to Ohio State. In the first class, I was absolutely petrified. I'd never been in a class like that. And I started writing down everything the professor was saying. And then later that evening, when I looked at my notes, I realized most of what I wrote down wasn't really important. It was about logistics and things like that. I'm thinking, I must have missed some stuff while I was writing it down. I was so concerned about taking notes that I wasn't listening. Now, you'll see me listening and writing because after almost 50 years of doing this, I've learned I have to multitask. To be an attorney and a judge, you have to listen and write, sometimes talk all at once. I hopefully do that well, but nonetheless, that's for us to do, not for you. Now, from time to time, there will be a bench conference, as we did here when we selected the jury. And during those times, that's to discuss matters that are not to be given to the jury. So it's not to keep you from hearing something you should hear, but to keep you from hearing something you shouldn't hear, so that I don't have to ask you again, disregard that too. So, for instance, if there's an argument of a point of law about a question and whether the answer to be given, I'll need to know what that answer is expected to be in order to make a ruling. So if we discussed all that in front of you, that just adds to your burden of trying to set that aside and forget what you aren't supposed to remember. So that's the reason for that. Okay, so with that, those are the instructions of the court that you're to follow. During the breaks, I'll tell you to, they were also referred to back in the day, Judge Hall always called them admonitions. I don't know why, but it's just stuck in my mind, and so he would always say at that break, remember the admonitions of the court. That kind of, to me, sounds like a warning or a threat. Just remember what I'm going to say. Remember the rules, remember the instructions. If I say admonitions because of habit, I'm not threatening you. Just trying to remind you, you have to consider and obey and follow everything I've said during those breaks. Okay, with that, we'll now proceed with opening statements. Opening statements will be made by can be made by each party. They are not arguments. They're not evidence. They're simply their prediction or belief as to what the case is going to be about and what the evidence will be. They're designed to assist you for that purpose, but for no other purpose. All right, on behalf of the state, Willie. Oh, is there a motion for separation of witnesses?
I don't think that's going to be done.
Okay. All right. Do you have a motion for separation? There's only two witnesses for the state. Mr. Porter is one of them. He stays. So.
No.
Okay. All right. You may proceed.
Thank you. May it please the court, ladies and gentlemen of the jury. Today, the state will prove beyond a reasonable doubt that this defendant, Alan Shoemaker, violated a protection order 4 times by sending 4 separate letters to his ex-wife, Teresa Shoemaker. Teresa and Alan were married for 35 years, but in July of 2019, the final decree of divorce was filed. In June 2023, Teresa filed a protection order. You'll probably hear me call it a CPO. It's a civil protection order is what it is, which would prohibit the defendant from having contact with her or her residence. That protection order included him being prohibited from sending her mail or mail to her residence at all. That protection order was granted, and the defendant was served with a copy of that order on July 7, 2023. The protection order remained in effect until June 19, 2025. On September 17, 2024, this defendant sent a letter to Teresa Shoemaker. On September 30, 2024, he sent another letter to Teresa Shoemaker. After Teresa received both of those letters, she went to the sheriff's office and made a report that the civil protection order in place had been violated. The protection order specifically prohibited this defendant from sending mail to her or her residence, as said. On May 1st, 2025, this defendant sent a third letter to Teresa, and she received it a few days later. Teresa again took the letter to the sheriff's office to report a violation of the protection order. And then on June 18th, 2025, the day before the CPO was set to expire, this defendant sent a fourth letter to Teresa, and she received it a few days later. Teresa took the fourth letter to the sheriff's office again and made the same report she had made for the previous three letters. Today, Teresa will explain that she filed for and received a protection order prohibiting this defendant from any contact with her. You will see a certified copy of that protection order and the four letters and their corresponding envelopes. You will then hear from Deputy Phil Porter, who took the reports from Teresa and gathered the necessary documents to prove these charges, as well as certified copies of a prior conviction in order to elevate these crimes to a felony. After you hear the testimony and review the evidence, I am beyond confident that you will find this defendant guilty of all four counts of violating a protection order that was in place when he sent four different letters to Teresa Shoemaker. Thank you.
All right, Mr. Shoemaker, you may address the jury with your opening statement.
Again, good morning. Basically, what we're here for today is to prove that whether I did write a letter to Teresa or not. I've got evidence. I've got witnesses to the point proving that it did not happen that way. So, basically, what I have to say. Thank you. God bless.
All right, your first witness, Mr. Willie.
Teresa Shoemaker?
Teresa Shoemaker.
Yes.
Right over here. Have you been sworn in the clerk's office?
Yes, sir.
All right. The trial will be streamed on YouTube. Do you wish to be shown or not shown? Does it matter? Pardon me?
I would prefer not show.
Okay, that'll be fine. All right. You have a seat over here. Hold on a minute. A technical problem here. I just noticed. I don't have controls here to control the cameras and stuff. Well, technology is wonderful when it works. This is the controls to the cameras. And we had this recently replaced following the usual caveat in the computer industry, the software industry, that if it's not broke, fix it until it's broke. So they keep giving us new updates and new improved versions. And it used to work fine, but now it doesn't. All right. Finally it came up. All right, now. All right, may proceed.
Thank you.
Please state your name for the record.
Teresa Shoemaker,
Can you spell your first and last name?
Teresa Shoemaker.
Thank you. Do you know an Alan Shoemaker?
Yes, I do.
And how do you know Alan?
We were married for 36 years.
At some point, did you file for divorce?
Yes, I did.
When was the divorce finalized?
In June of 2019.
Was the divorce amicable? Did everyone get along?
No.
Why is that?
Well, Alan didn't seem to accept that we would be divorced, so he fought it a little bit.
Do you see Alan Shoemaker in the courtroom today?
Yes, I do.
Could you point to him?
He's over there.
Please let the record reflect the witness has identified the defendant.
So ordered.
During the time you were married to the defendant, did you ever see his handwriting?
Yes, I did.
Could you identify his writing if you were to see it?
Yes, I can.
Did you file a CPO against the defendant in 2023?
Yes, I did.
Why is that?
Well, because I was receiving mail that had what could be seen as threatening content.
I'm going to hand you what was previously marked as State's Exhibit 5. Do you recognize that?
Yes, I do.
And what is it?
This is the order of protection that was granted.
And that's here in Highland County.
Yes, it is.
Around September 17th, 2024, did you receive mail?
Yes, I did.
Where did you receive your mail?
At 4328 Newman Road, my home address.
4328 Newman Road.
Yes.
I'll give the bailiff what has previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes, I do.
What is it?
This is a letter that was sent to my home address, but it's addressed to our youngest son, Ethan, and in care of his brother and sister, Seth and Courtney.
What is the post office date stamp on that letter?
September 17, 2024.
Do you recognize the writing in that letter?
Yes, I do.
And whose writing is it?
That's Alan's writing.
What is the return name on that letter?
The return,
The return name on that letter.
oh, Alan Shoemaker.
And you said Ethan, Seth, and Courtney are your children?
Yes.
Who all lives at the 4328 Newman Road address?
Myself and my parents.
Do your children live at that address?
No.
Have your children ever lived at that address?
No.
Within the letter, is there a Mary Grace referenced?
Yes, there is a Mary Grace reference.
Do you know a Mary Grace?
I do not.
Has he ever sent other letters in care of a Grace Shoemaker or a Mary Grace Shoemaker?
Yes, he does.
Does a Mary Grace Shoemaker live with you?
No.
After you received this letter, what did you do with it?
I took it to the sheriff's department and filed a complaint.
Is that document you have in front of you, is that the original envelope and letter, or is it a copy?
This is a copy.
Is it a true and accurate copy of the envelope and letter that you received?
Yes.
Thank you. Around September 30th, 2024, did you receive mail?
Yeah.
Where did you receive your mail?
At my home address.
4328 Newman Road.
Yes.
I'll have the bailiff hand you what has previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, I do.
Within the contents of that letter, are you able to recognize the writing in it?
Yes.
And whose writing is it?
That's Alan's writing.
What is the post office date stamp on that?
September 30th, 2024.
And what is the return name on that letter?
Alan Shoemaker.
Who is it addressed to?
This is, again, addressed to Ethan with Seth and Courtney in care of.
And those are your children, correct?
Yes.
And none of your children would live with you at the 4328 Newman Road?
That's correct.
Did you provide those letters to your children?
Yes.
And you already testified that a Mary Grace Shoemaker does not live with you, correct?
That's correct.
After you received this letter, what did you do with it?
Took it to the sheriff's department to file a complaint.
Gotcha. And is that the original envelope and letter, or is that a copy?
This is the copy.
Okay. Is it a true and accurate copy of the envelope and letter?
Yes, it is.
As you received it?
Yes.
Around May 1st, 2025, did you receive mail?
Yes.
Where did you receive your mail?
At my home address, 4328 Newman Road.
I'll have the bailiff hand you what has previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
Yes, I do.
Within the contents inside, are you able to recognize the writing in that letter?
Yes.
And whose writing is it?
This is Alan's writing.
Back to the envelope, what's the post office date stamp on that?
May 1st, 2025.
And what is the return name on that?
Alan Shoemaker.
Who is that letter addressed to?
This is addressed to the Shoemakers.
The Shoemakers. What address is listed on that?
4400 Newman Road.
Do you live at a 4400 Newman Road?
I do not.
Are you familiar with the property?
Yes.
At 4400? How are you familiar with that?
Well, Alan and I lived there early in our marriage.
Okay. What happened to it after that?
Well, it was going to go into foreclosure, so my aunt and uncle, Ron and Nancy Green, assumed the loan and signed it over to them.
So, to your knowledge, your aunt and uncle, the Greens, own that property now?
Yes.
To your knowledge, does anyone live there?
No.
So it's vacant?
Yes.
You were married to the defendant for 35 years?
Yeah,
correct?
36, actually.
Within that time span, were you acquainted with his family?
His family, absolutely.
Do you know if there are other shoemakers that live on Newman Road?
No.
Now, this letter, did you ever read it?
Yeah.
I'll reference you to probably the back side of that letter in the middle, maybe, where there's a list of names.
Yes.
Do you see that?
Yes, I do.
Among those names, there is an Angie Roush. Do you know who that is?
Yes, she was my supervisor at work.
Work, you said? There's also a Teresa Rhodes. Do you know who that is?
Yes, she was my coworker.
And to your knowledge, is there any connection between your children and either Angie Roush or Teresa Rhodes?
No.
When you received this letter, did you understand it to be intended for you or your household?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
On June 18th, 2025, did you receive mail?
Yes.
Where did you receive your mail?
At my home address, the 4328 Newman Road.
I'll have the bailiff hand you what has previously been marked as State's Exhibit 4 for identification purposes. Teresa, do you recognize that?
Yes, I do.
Within the contents of that, in that letter, were you able to recognize the handwriting?
Yes.
And whose writing is it?
This is Alan's writing.
And then back to the envelope real quick. What does the post office date stand on that?
June 18, 2025.
And what is the return name on that letter?
Alan Shoemaker.
Who's it addressed to?
The Shoemakers,
And what address is listed?
4400 Newman Road.
But you do not live at 4400 Newman
Do
Road,
not.
correct? And you don't know of any other shoemakers that live on Newman Road?
Correct.
Did you read this letter?
Yes.
There's a section in there, probably on the second page or so, that references a Dr. Drew. Do you see that?
Yes.
Are you familiar with who that is referring to?
Yes.
Who is that?
I was going to him. He was my counselor for a little while.
And what does that letter specifically say about Dr. Drew?
Give Miss Collins Dr. Drew's information.
To your knowledge, was the defendant aware that you were seeing Dr. Drew?
Yes.
I'll reference you to probably about the first page. You see a line that starts with the number 2, and then it says the vehicles bought by the corporation.
Yes.
And so on. Do you know what that is referring to?
It would be trucks that were purchased in his personal business.
And when it says corporation, is that an LLC? Is it LLP? Anything like, what is it?
I believe he had it, the company put into an LLC,
Do you know around when that was?
2002.
And how old were the children at that time?
Our oldest, I believe she was 15. And then the other one, he would have been 12, and then 2.
So all minors still,
Yes.
and wouldn't be listed as members of the board or anything like that, correct?
Well, their names were on paper as being on the board.
When you received that letter, did you understand it to be intended for you or your household?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
No further questions?
All right, Mr. Shoemaker, if you wish to ask the witness questions, you may do so at this time. Stand at the lectern, please.
Thank you. Okay. There was 2 letters written to Ethan Shoemaker, and it was sent to the address of the 4328 Human Road.
Correct.
Okay. You received those letters.
Correct.
And you opened them?
No.
You didn't open them?
No.
You gave them to Ethan,
Yes.
and then he gave them back to you.
He came to the house and he opened them and read them and left them at the house.
Okay. Did he ever receive any other mail at that address?
Yes.
So that was an address where he had told me that if I needed to get a hold of him to send letters to that address.
Objection.
I'll sustain that you're not permitted to testify at this point. You have to ask questions.
Correct.
So that question is stricken.
You said that none of them was ever lived at that address,
That's correct.
but they did receive mail at that address, at least two of the children.
Correct.
And the other one was our daughter, was Courtney.
Yes.
Okay. Where do you work?
At Connection Incorporated in Wilmington, Ohio.
Okay, what is that? What does it do?
Objection, relevance.
I'll allow that question. We're not going to go in too deeply, but she can answer that.
We're a computer distribution and configuration center.
And that company has a, I want to say a tech department.
Correct.
And what does that department do?
Objection.
The Cal sustained that. That's not relevant.
I'm sorry, did you,
Pardon me?
you sustain?
I sustain the objection.
Okay, thank you. I took, when I was in Madison, I took a year of computer classes. In that class, you can take a copy of a letter.
I'm going to object. This is,
Okay, I'm going to sustain that. You're not asking a question, you're testifying. So the jury will disregard that.
In that tech room, what's the purpose of the tech room? Without trying to lead, the purpose of the tech room is to set up computers to make them work like the customer would like them to work.
objection, Your Honor. This is not relevant to the charge.
I'm going to sustain it. There's no relevance here. So move on to something else.
Okay. I guess at this time I have no further questions. Thank you. God bless.
Redirect.
Teresa, you already testified that you reside at 4328 Newman Road, correct?
Correct.
And that's in Highland County?
Yes, it is.
Has the defendant ever told you, to your knowledge, has the defendant ever been told not to send mail to your children at your house?
Correct.
Have the children ever lived? You already testified about that. The children have never lived at your address.
Correct.
I'd like to back up this State's Exhibit 5, if you can find that. That's the certified copy of the CPO. If you flip through that, I think it's page 2 or 3. There's a box with a 6 next to it. Do you see that?
Yes.
Could you read that up until about the midway of that section?
Respondent shall not initiate or have any contact with the protected persons named in this order or their residence, businesses, places of employment, schools, daycare centers, or child care providers. Contact includes, but is not limited to landline, cordless, cellular, or digital telephone, text, communications, posting a message, or communications by any other means directly or through another person.
That's probably good. Now, if you flip back over to the first page, who's the respondent listed on that?
That'd be Alan Shoemaker.
And what's the date of birth? Is there one?
Date of birth,
Yes, ma'am.
October 14, 1958.
And husband of 35 years, you know his birthday, I assume.
Yes.
Is that his birthday?
Yes, it is.
All right. No further questions.
All right, you may step down. Thank you. Your next witness.
Deputy Phil Porter.
Have you been sworn in? I have. Just have a seat there then. All right, you may inquire.
Please state your name for the record.
Phil Porter.
Are you currently employed?
I am, sir.
And where are you employed?
I'm employed at the Highland County Sheriff's Office.
How long have you been employed at the Sheriff's Office?
I was a reserve deputy since 1989, and I had a full-time job elsewhere. I retired from my former job and started working for Sheriff Sanders in 2024.
And working at the Sheriff's Office, what are your job duties there?
Patrol.
Any other, do you investigate or do anything else of the sort?
Yes, we'll investigate some things like this case. Anything, really needing an expertise. We have our detectives handle that.
Gotcha. Within the course of your duties, have you ever had interactions with an individual named Teresa Shoemaker?
I have, sir.
And what was the nature of those interactions?
It was where she came and she brought an envelope and some documentation from or that she received in the mail by her ex-husband.
Did she inform you of a protection order? Or anything?
Yes, she did. She did advise me that.
Are you familiar with Alan Shoemaker?
I am.
Do you see Alan Shoemaker in the courtroom today?
I do, sir.
Could you please point to him?
He's sitting next to Mr. Kirk.
Please let the record reflect the witnesses identified the defendant.
Sure.
What is the defendant's date of birth?
10/14/58.
1958.
Yes, sir.
Did you prepare a report during your investigation?
I did.
You should have State's Exhibit 1 up there.
Thank you. Thank you.
Do you recognize that?
I do, sir.
And what is it?
It is a copy of an envelope to Ethan Shoemaker, 4328 Newman Road.
During your investigation, have you ever handled that before?
Yes,
And where did you get it?
from Teresa.
What is the return name on that letter?
Alan Shoemaker.
And what is the address? You already said 4328, correct?
Yes, sir.
Do you know who lives at that address, the 4328?
Teresa and her parents.
And that address is in Highland County, correct?
It is, sir.
Is that the original envelope and
This
letter?
is
or
a
is it
copy.
It's a copy. Is it a true and accurate copy of the envelope and
It
letter
is.
that you received?
It is.
And you should have State's Exhibit 2 up there. Do you recognize that?
I do, sir.
And have you ever seen that before?
I have, sir.
And where did you see that?
It was brought to the office when Teresa wanted to file another complaint, different incident.
And what is the return name on that letter?
Alan Shoemaker.
And what is the address the letter was sent to?
It is 4328 Newman Road.
And again, you already stated that is Teresa's residence.
Yes.
Is that the original envelope and letter, or is it a copy?
This is a copy.
Is it a true and accurate copy of the envelope and letter that you received?
Yes, it is.
And then up there, you should have State's Exhibit 3. It should be in one of the envelopes. You recognize that?
I do, sir.
And how do you recognize that?
This was given to me by Teresa on another occurrence.
Another occurrence. What do you mean by that?
But one of the 4 that she had received in this span of time
And then-
from,
Brought them into the sheriff's office?
yes,
What is the return name on that letter?
it's Alan Shoemaker.
And what is the address the letter was sent to?
The Shoemakers at 4400 Newman Road.
Is that address in Highland County?
Yes, it is.
And you just testified that Teresa Shoemaker lives at 4328
Yes,
Newman
sir.
Road, correct? Do you know who lives at the 4400 Newman Road residence?
It's abandoned at 4400.
To your knowledge, are there any other Shoemakers that live on Newman Road
No, sir.
other than Teresa?
Teresa and her parents.
Where is the 4400 Newman Road address in relation to Teresa's?
It is like the next residence up north of Teresa's residence.
When you say next, so if you were pulling out of Teresa's driveway,
I would turn right.
right, and then how far away is it?
Maybe it's the next place up at 100 yards, 200 yards.
Is it on the left or the right?
It's on the right as you're
So
driving.
you pull out of her driveway, and it's
It's on the right. We're coming around the curve. It's on the right.
Back up just a second.
Okay.
You testified that Teresa brought that in, correct?
Yes.
And she made a report that she was the one that received that letter?
Yes.
And brought it to the sheriff's office, correct?
Yes, sir.
Are the contents within that envelope the same as they were when Teresa brought that letter in?
It is, sir.
Up there you should have State's Exhibit 4.
There's also the letter was in there.
Correct. You recognize that envelope and the letter inside of it?
I do.
And how do you recognize it?
It is the letter that Teresa brought to the sheriff's office to file another complaint.
Another complaint, so 4 total.
Yes, sir.
What is the return name on that letter?
Alan Shoemaker,
And what is the address that letter was sent to?
4400 Newman Road.
Are the contents within that envelope the same as they were when Teresa brought the letter in?
They are, sir.
I want to switch gears just a second. Did Teresa ever advise you that there was a civil protection order in place?
She did. She did on the first time she showed up. She did, yes.
Were you able to confirm that civil protection
Yes.
order? You should have State's Exhibit 5 up there. Do you recognize that?
That is the civil protection order that she supplied to me, showing that she did have one that was in play.
Is that a certified copy?
Yes, it is.
Is there a file stamp that the protection order was issued?
Yes, sir. Top right here is showing July 28th of 2023.
And I think it's down towards the bottom maybe. What date are the terms of that order effective till?
Until June 19th, 2025.
In that civil protection order, can you determine who the protected person is?
Yes, the petitioner, it's Teresa Ann Shoemaker.
And can you determine who the respondent is or who the protection order is against?
That is Alan Wayne Shoemaker.
And is there a date of birth listed for Alan Shoemaker in that protection order?
There is. It's 10/14/58.
From looking at that civil protection order, can you tell us what type of contact is prohibited?
I can. You want me to go to the where it's
Page 3, I think,
Yes.
is around where it is. And then page 6 as well.
Okay, page 3.
You don't have to read the whole thing if you want to summarize it.
Okay, on a CPO, they'll have blocks and the instructions. The ones that are checked is the ones that apply to the respondent. Number 6 says the respondent shall not initiate or have any contact with protected persons named in this order or their residences, business, places of employment, school, daycare centers, or child care providers. Contact includes but is not limited to landline, cordless, cellular, or digital telephone, text, instant messaging, fax, email, voicemail, and delivery service, social media, blogging, writings, electronic communications, posting a message, or communications by any other means, directly or through another individual, another person.
And then on page 6, I think there's a handwritten note on there as well. You see that?
I do, box 26.
And what does it say?
It says Alan Shoemaker shall have, absolutely, and it's emphatic here, no contact with Teresa Shoemaker, even by mail. And it's right here.
I'll have the bailiff hand you what has previously been marked as State's Exhibit 6.
Thank you.
Do you recognize that?
This is a notice to serve of protection order.
So it's a service of the protection order as well.
Yes, yes.
Is that a certified copy?
It is.
And by looking at it, can you tell when it was served on the defendant?
July 7th, 2023.
And who served that protection order?
It would be Deputy Bingaman, Brian T. Bingaman.
Is there a date stamp that order was filed?
Yes, it's July 12th, 2023.
I'll have the bailiff hand you what has previously been marked as State's Exhibit 7.
Thank you.
Do you recognize that?
This is a judgment entry of confinement.
And in layman's terms, can you kind of explain what that means? Is it a conviction? Is it a sentencing? Is it?
It's sentencing. It's where, I guess, after he had been sentenced.
After he had been convicted? As
Convicted and sentenced and
Gotcha.
to confinement.
And is that a certified copy?
It is.
Who's the defendant listed on that entry?
The defendant is Alan W. Shoemaker.
And does it have his date of birth on that entry?
It does, right below his name, 10/14/1958.
And that's the same date of birth as...
It's before, yes, the other documentation.
What is the case number?
It is 20 CR 220.
And what was the defendant convicted of?
Violating a protection order or consent agreement.
What's the code section on that?
It is 2919.27, subsection A, paragraph 1.
And then on the front there, what is the file stamp date?
April 14th, 2021.
No further questions.
All right, Mr. Shoemaker, you may ask questions of the witness.
Just got a couple questions.
Okay.
Whose name's on the protection order? There's three names on the protection order.
I see two. Teresa Ann Shoemaker as a petitioner and Alan Wayne Shoemaker as a respondent.
No, it says who I'm not to be able to write to. It's got three people's names on that. There's two of them.
Your Honor, the defendant has the exhibits. If he could direct us to what page he's talking about, that might speed things up.
Yeah, I don't see.
What page are you looking at that you want to direct his attention to?
I don't see it either. I don't know where it is. Okay, Teresa lives at her parents' house on Newman Road. That's where she resides. She resides at her parents' house. Correct?
I believe, I'm not sure who the name of the property is in. I don't know if the parents live with her or she lives with her parents.
So basically, we don't see any other names on it. So the only name for the protection order to be against would be if I would write to Teresa herself.
I don't understand exactly what you want me to.
The protection order says that I can't write to Teresa. I cannot contact her at that address.
Oh, right, yes. And you're not allowed to do it through other individuals or other means as well.
Even though that's where they receive their mail.
I don't know where they receive their mail, sir.
She already testified.
Objection.
Sustained.
No further questions.
Redirect.
Deputy Porter, can you go back to the certified copy of that CPO real quick? And on the third page of that, you read the entire thing off, box 6.
Yes.
And in layman's terms, what is that box saying? Don't reread it, just in your own words. What is that box saying?
Don't have any contact, period.
At all?
At all.
Mail to the
Period.
residence?
Mail, anything, yes.
And the residence is included in that, correct?
Yes.
No further questions.
All right, let me step down. Any next witness?
No further witnesses, Your Honor.
Okay.
We would move to admit our exhibits 1 through 7, Your Honor.
All right. Ladies and gentlemen, at this time we're going to take a brief recess to address a couple of legal matters. So I'm going to ask you to go back to the jury room. We shouldn't be too long, and then we'll bring you back in. Remember the instructions of the court.
Please rise.
All right, the state is moving admission of its exhibits. That will be exhibits 1 through 7. Mr. Shoemaker, do you have any objections to the admission of any of those exhibits?
No, sir.
All right, then they will be admitted. And do you have anything you wish to bring before the court at this point, Mr. Shoemaker?
No, sir.
All right. Then the state rests. So, your evidence will be next. And you intend to call or present any testimony?
Yes.
All right. How many witnesses do you have?
There's 3.
3. And who are they?
Danny Shoemaker, which is my brother. Carl Flynn, who is the minister of the church. And Michael Johnson, Sr. That's it. That's the 3.
He's the one from the institution.
He's the one from the prison, yes.
Now, you, by presenting him as a witness, I assume there's going to be testimony. He was your, apparently, what, a cellmate or something?
Excuse me?
Was he a cellmate of yours, or you just knew him?
Yeah, he was right next
From the
to
institution?
He was right
Okay.
next to me.
So you understand that that'll mean that the jury's going to understand that he's a prisoner because he's in custody, and he was the court was informed he's a flight risk, so he's going to be shackled. You understand that?
Yes, sir.
All right. And it'll also obviously indicate if he knew you, it was from prison, so it's going to tell the jury you were in prison. You understand that?
Yes.
All right. Okay. All right. Then, let's see. We'll take about 5 minutes and come back then.
John Rice.
we're back on record. The state has rested. This court has admitted the 7 exhibits that were testified to during the state's case. And we'll now turn to the defendant's case. Mr. Shoemaker, you want to call your first witness?
I'd like to call Michael Johnson Sr.
Michael Johnson, Sr.
Correct.
Were you sworn in the clerk's office? All right. No, it's hard, so just put your hand up, right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. See you right there. All right, Mr. Shoemaker, you may inquire.
Mr. Johnson, do you know who I am?
Yes.
Well, first of all, let's get his name and address, please, in the record.
Okay, what's your full name?
Michael Lee Johnson,
And where do you reside at this time?
Lake Erie Correctional Institute.
And this is where we met?
Yes.
How close were we?
Side by side in the same cube, bottom racks, here right across from me.
We basically went pretty much everywhere together. We went to the chow hall.
Objection,
together.
he's testifying.
Yeah, that's called leading. You're not allowed to do that. You have to ask questions, so the objection is sustained.
You basically saw him.
Objection, he's leading.
Yeah. You have to ask questions. You can't lead.
Right. Did you see me write letters while we were at there?
Yes.
Do you know who those letters were written to?
Yeah, to the church people that you had that sent you the food box, or the clothes box.
Right. So you basically seen every letter that
Objection.
Yeah, I'm going to sustain it. You cannot put words in his mouth. You have to ask him questions.
Right. Okay.
So that's sustained.
Did you see the letters that I put in the mailbox?
Yes. I went with you.
And they were written to who?
To the people from the church.
Was there ever any letters written to Ethan Shoemaker?
No. Not that I know.
In the prison, they've got what's called a red line. Can you explain what that is?
It's when they call you up to the red line to talk to the warden or whatever, it's when they want to talk to you about something important.
Was I ever called to the red line?
Yes, you're called to the red line.
Do you remember what that was about?
Writing a letter or something. You wrote a letter to somebody and they told you couldn't write to them no more.
They was telling basically what they...
Objection.
Sustained.
What I was going there for was writing a letter
Objection.
Yeah, okay, again, that's sustained. That's leading. You have to ask him questions, not tell him what you want him to say.
So you've never really seen me write a letter to Teresa Shoemaker?
No, never.
It was always to one of my kids.
Yep. Actually, I think it was your son.
So when they call you to the administration, did I tell you what they said?
Objection.
Okay. That's sustained. You're asking him to say what you said, and that's hearsay.
Right. Okay. What kind of letters, what kind of envelopes do we receive at the prison?
It's called a free envelope. They give them to you when you're, what do they call that, when you ain't got no money, when you're indigent and you're only living off state pay.
Can you get any other envelopes from at the prison?
You can buy from the commissary, you can buy embossed envelopes. But we never had no money to buy them. We got $12 a month to live on.
Did you see, when I went to the commissary, did you see the contents of what I got?
Yeah, every time.
Did you ever see an envelope?
No, he never bought no envelopes. We got free ones every month.
So basically, you're saying that we were basically...
Objection.
Sustained.
No further question. Thank you.
All right. Cross?
No, I don't think so. Maybe just put us
Mr. Johnson, have you ever been convicted of a felony in the past 10 years?
Yeah,
Is it 1? Is it 2, 3? Do you know how many?
just one.
And what was it?
It was called, well, it was domestic violence when it first started. They worked it down to something else.
Would menacing by stalking ring a
Yeah,
bell?
that's what they made that up. I mean, there was never no stalking or nothing. Me and my girl was together for the whole time.
But you either were convicted or you pled guilty to that, and you were...
Well, I pled guilty to that to get a bond, personal bond, after being in jail for 5 months or 6 months.
Menacing by stalking, that's after being told to leave someone alone, you continue to harass them. That's basically what the charge is, correct?
She was the one that came pick me up from the jail, too.
Nothing else.
Redirect. You can ask him questions about what he was asked by the Mr. Wilson.
No. Thank you.
All right. He can ask students. Thank you. Next witness,
Danny Shoemaker.
Danny Shoemaker.
Danny Shoemaker.
Were you sworn in the clerk's office? All right, just have a seat over there. If you have a cell phone, make sure it's off. You all right?
Yeah, I got herniated disc in my back. My right leg is.
Yeah, I have too. It's not fun. All right. You may inquire.
Thank you, Your Honor. Would you please state your name,
Danny Joe Shoemaker,
your address?
7860 East New Market Road, Hillsborough.
Is that where you receive your mail?
No. Received mail at P.O. Box 123, Hillsborough, Ohio.
Okay. What is your relationship to myself?
You're my brother.
What is your relationship to my children?
I'm their uncle.
What's your relationship to Teresa?
She's my ex-sister-in-law.
She's your ex-sister-in-law at this time. Okay. Did she ever ask you for information or anything?
No.
Objection. Withdrawn.
Well, I'm going to overrule that for now.
Did she ever ask you to come into the house?
Which house?
My house. It's on State Route 124.
She was gone. You were in jail. So no, she never asked me to come into the house, no.
Did she ever take anything out of the house?
Just her personal belongings.
And I don't know whether I can bring this up. I'll bring it
I
up.
won't know until you ask.
I understand. In the divorce, she stated that she didn't want anything to do with the house.
That's correct.
Objection.
All
What's
right.
the relevance of this?
That's not relevant. You know, that happened long ago. We're here about the
That's
matters
what I-
before the court, so
what I was
that is
getting.
stricken, and the objection is sustained.
Did you ever receive any order forms or anything for clothing or something like that?
Yes, a couple times.
Did you ever fill that order?
Yes, I did.
Okay. Did she ever get that? I mean, did you ever show her that list?
Show who?
Teresa.
No.
Yet she has an order. She does have an order.
Objection.
Okay, I'm going to sustain that. You're testifying, and I don't know what the relevance is of this either, so sustain.
No further questions. Thank you.
Cross?
None, Your Honor.
All right, you may step down, Mr. Shoemaker. Thank you. Be careful.
Been sitting out there, my legs was.
Take your time. Yeah. You can stay or you can leave, whatever you want. Next witness.
Carl Flem.
What's the last name?
Flem. F-L-E-M.
Okay. He apparently is not here. Your next witness?
That's the end of it. That's the three witnesses that I had ordered.
All right. Okay, we're going to take a break. I'm going to ask the jurors to retire to the jury room and have a couple of matters we need to discuss at this point. So if you would go ahead and retire. Ms. Lawson, if you would remain, and we're going to have to ask you a few questions. Ms. Ruffin, you go back, please. You can be seated. Yeah. All right. Everybody be seated, please. Okay. Juror Sharon Lawson, number 2, is still in the courtroom, and the reason she indicated to Bailiff Reno after Mr. Danny Shoemaker testified that she used to work with him, and he was not stated as a witness in the voir dire. And have you had any contact with him since then?
No.
How long ago has that been?
5 years.
All right. And the fact that you used to work with him, do you feel it would have any impact on your consideration of the case one way or the other, or his testimony one way or the other? Okay. You wish to inquire?
No.
You want to ask her any questions?
No, thank you.
All right. You may retire and go back to the jury room. Thank you. Yeah, thank you for your candor. All right. Those are your 2 witnesses. Are you going to testify?
No, sir.
Okay. All right. So then you're resting.
Yes, sir.
All right. Any rebuttal?
Yes, Your Honor.
Okay. Just one?
This one.
All right. Marcia? I have a really 2. I thought I printed it down. It should be on the computer. I have to go in and change it, and it should say down here, count 2, and count 2, and it has in count 3 lines. So if you would find that, it should be on my computer. I think I printed it out and came out for print it. If not, should be able to find it on the Word and print it out for me. All right. While we're on a break, or the jury's out of the room, I have, if you would hand these to Mr. Shoemaker and counsel, those are the jury instructions that I have prepared, and then I have the verdict forms as well. And so I'll give you a few minutes after we're done with the case to look at those to make any objections or requests.
What's the case number of this case?
All right. Then let's go ahead and bring the jury back in, and we'll do the one witness. Be seated, please. All right. The defendant has rested, and the state, as I understand, is going to call a rebuttal witness. All right. You want to call that witness now?
Deputy Phil Porter.
Deputy Porter, you're still under oath. So, proceed, please. All right, you may inquire.
Deputy, I'm going to have the bailiff hand you what has previously been marked as State's Exhibit 8 for identification purposes.
Thank you.
Do you recognize that?
I do, sir.
And what is that?
That is a copy of one of the envelopes that Alan Shoemaker sent these shoemakers.
One of the original.
Originals, yes, sir.
Is it unredacted in comparison to one of the other?
It is not.
Wait a minute. It is not unredacted?
Is that
unredacted?
Is that an unredacted version?
That is an unredacted.
Okay.
I'm sorry.
I think it was a double negative there, as I recall from grammar school. Yeah, go ahead.
Is that a true and accurate copy of the envelope that you received from Teresa? What is the return address on that envelope?
It is Adam 826146, Lake Erie Correctional Institute, P.O. Box 8000, Connote, Ohio 44030.
Lake Erie Correctional Institute, correct?
Yes.
Do you also see an indication that these envelopes were free mail?
I do. Show a free mail over here.
I'll next have the bailiff hand you what has previously been marked as State's Exhibit 9 for identification purposes. What is that?
This is a copy of an envelope as well.
One of the originals?
Yes.
Is that correct? Is that an unredacted version of that envelope?
This is unredacted.
And is it a true and accurate copy of the envelope that you received?
Yes, sir, it is.
And what is the return address on that envelope?
826146. It's Alan Shoemaker, 826146. P.O. Box 8000, Lake Erie Correctional Institute, Connote, Ohio 44030.
And does that have the same free mail listed at the top?
It does not.
It does or does not?
It does not.
Next, I'll have the bailiff hand you what has previously been marked as State's Exhibit 10 for identification purposes.
Thank you, sir.
Do you recognize that one?
I do. It's a copy of one of the original envelopes.
And is that an unredacted version?
This is also unredacted.
And what is and is it a true and accurate copy of the envelope that you
Yes.
received? What is the return address on that envelope?
Alan Shoemaker, Lake Erie Correctional Institute, P.O. Box 8000, Connote, Ohio 44030.
And does that one have a free mail listed at the top of that?
This one does.
No further questions.
Cross-examination, Mr. Shoemaker.
No questions.
All right, you may step down. Any other witnesses?
No, Your Honor.
All right.
We move to admit our exhibits 8, 9, and 10.
8, 9, and 10.
Yes, sir.
Any objection?
No.
Okay, they're admitted. All right, ladies and gentlemen, I'm going to ask you to take about one more 10-minute break, and then we're going to come back and I'm going to give you instructions on the law. Then we'll break for closing arguments and then final instructions after lunch. So if you'd return to the jury room just for maybe 10 minutes. Thank you.
Please rise.
All right, be seated, please. All right. This is a pretty straightforward case. The jury instructions are actually the same as they were in the last case Mr. Shoemaker had. I think that was the last trial we had on this particular charge. Other than that one was one count, and these, I believe, as I recall, and this is 4 counts, but otherwise pretty much the same. So at this point, Mr. Shoemaker, you have the right to request any special instructions you think you may be entitled to under the law, or to object to any of the proposed instructions. These are standard instructions that come from, it's called the Ohio Jury Instructions, that are prepared by a panel of judges statewide that have done this for years. They update it every year. So that's where I get it from. So at this point, do you have any requests for any instructions?
I don't need anything, thank you.
Okay. Ms. Collins?
I just read through them quickly, Judge. The case number is the old case number.
Oh, okay. Thank you.
And also, the defendant testified at the prior hearing, or the prior trial. On page 2, it says the testimony of the defendant is to be weighed by the same rules that apply.
Okay.
You need to put the...
Yeah, I'll change that to say that he's not required to testify, and
That's
he
all I
cannot
could
consider it
find.
for any purpose. Okay.
Those are the only two things I could find.
All right. No request for instructions from
No,
the
Your Honor.
state? All right. Okay, I'll need to go back and make a couple of changes then. Case number's minor, and then I'll go in and on page 2, what they're talking about there, Mr. Shoemaker, is that when a defendant exercises the right not to testify, as you have, the court gives an instruction to the jury that they're not permitted to consider that for any purpose, as opposed to what's in this one, which is defendants testimony to be weighed by the same rules. So other than that, I'm going to make a change. So I'll be just a couple minutes.
Right.
Let me see, Mr. Shoemaker. All right. I'm glad the bailiff to give each of the parties a copy. I did make another change. I saw on page let's see here. It was on page 2 about the evidence of commission of crime other than offenses which is charged. That was the limited instruction that's only for purpose of the prior conviction. The original one also said, and for purposes of determining credibility, but since it did not testify, that's not appropriate, so I struck that out. So, all right. If you would, then bring the jurors in, please. Check to make sure there's all 10 there. Go ahead. Imagine you didn't think jury duty included popping up and down a number of times like a jack-in-the-box. That we have to send a jury out to do certain things about legal matters and things that we have to discuss on the record that the jury can't be present for. So since this case has moved along pretty quickly, you've done a lot of getting up and down here in the last hour. So we'll just do it twice more, once for lunch and then once when we send you back. All right. Now, ladies and gentlemen, you've heard the evidence, and now it's the court's duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts. The court provides instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and apply the laws as given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. A plea of not guilty is a denial of the charge or charges in this case and puts in issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense that's been charged in the indictment. Now, reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will apply the test of truthfulness that you apply in your daily lives. These tests can include the appearance of each witness on the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, it's not necessary the defendant take the witness stand in his own defense. He has a constitutional right not to testify, and the fact that the defendant did not testify must not be considered for any purpose. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposing party. And during cross-examination, the counsel was able to inquire to some matters that did not relate directly to issues before the court. Such questions and answers are permitted for the purpose of helping you determine credibility and the weight to be given to the testimony of the witness and for no other purpose. Evidence was received about the commission of a crime other than the offenses with which the defendant is charged in this trial. That evidence was received only for a limited purpose. It was not received, and you may not consider it to prove the character of the defendant in order to show he acted in conformity or in accordance with that character. If you find the evidence of the other crime is true and the defendant committed it, you may consider that evidence only for the purpose of deciding whether it proves the defendant had a prior conviction as specified in the indictment. Testimony was presented that the defendant was incarcerated when letters in issue were allegedly mailed. You may not consider the fact he was incarcerated for any purpose, nor may you speculate as to the reason for that incarceration. You may have observed during the course of this trial the defendant is in the custody of the sheriff's office. This is not an indication of his guilt or innocence. It simply means he's not been able to post the bail the court required during the pendency of this action. You may not consider the fact he's in custody for any purpose. Now, the defendant has exercised his right under the law to represent himself rather than being represented by an attorney. You're not to make any inference or deduction regarding the evidence and issues in this case based on the fact he's representing himself in this case. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has admitted into evidence during the trial. There will be 10 of those. Evidence may be either direct or may be circumstantial or may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. That includes, of course, the exhibits that were admitted in the trial, during the trial. Now, circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of humankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. In other words, you cannot stack one inference upon another inference to reach a factual conclusion. If the circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with the defendant's guilt or wholly inconsistent with any other reasonable theory he's not guilty and are so convincing as to exclude a reasonable doubt of guilt. When the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence, convinces you beyond reasonable doubt the defendant is guilty. The evidence does not include the indictment, the opening statements, or closing arguments of counsel. Opening statements and closing arguments, as the court has indicated previously, are designed to assist you, but they are not evidence. Any statements that may have been stricken by the court that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection, any question, or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in a question that was not answered. Now, a number of exhibits have been introduced, 10 in all, and testimony relating to them has been admitted into evidence, and you may consider whether those exhibits are the same objects and the same conditions as they were originally. You will determine what weight, if any, the exhibit should receive in light of all the evidence. Now, the law under which the defendant is charged in counts 1 through 4 is entitled Violating a Protection Order and is numbered Ohio Revised Code 2919.27. Actually, violating a protection order or a consent agreement. No person, this law states in the pertinent part as follows. No person shall recklessly violate the terms of a protection order issued pursuant to section 2919.26 or 13.31 of the revised code. So, ladies and gentlemen, in this case, the defendant is charged in counts 1 through 4 with violating a protection order or consent agreement under this section. Before you can find the defendant guilty of any of the 4 counts, you must find beyond a reasonable doubt that on or about the date charged in those counts in Highland County, Ohio, the defendant did recklessly violate the terms of a protection order issued pursuant to section 2919.26 or 3113.31 of the Ohio Revised Code. So the essential elements of violating a protection order or consent agreement as charged in counts 1 and 4 are as follows: that on or about the date alleged in count 1, which is September 17, 2024, count 2, September 30, 2024, count 3, May 1, 2025, and count 4, June 18, 2025, in Highland County, Ohio, he recklessly violated the terms of a protection order issued pursuant to Section 2919.26 or 3113.31 of the Ohio Revised Code. Now, it's not necessary the defendant, It's not necessary that the state prove that the offense was committed on the exact date as charged in the 4 counts of the indictment. It's sufficient to prove the offense took place on or reasonably near the date claimed in that count. Before you can decide whether the state has proved beyond a reasonable doubt all of the essential elements of the offenses with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, the state must prove beyond a reasonable doubt that the defendant was served with a copy of the order or was shown the protection order or was informed by a law enforcement officer that a protection order had been issued prior to the alleged offense. Served means actual delivery of the protection order to the defendant. Protection order means an order issued by a court upon evidence presented for the safety and protection of a protected person. Law enforcement officer means any of the following: a sheriff, deputy sheriff, constable, police officer of a township or joint police district, marshal, deputy marshal, municipal police officer, member of a police force employed by Metropolitan Housing Authority under Division D of Section 3735.31 of the Revised Code, or State Highway Patrol trooper. Now, a person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or be of a certain nature. The person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Recklessness requires more than mere negligence. A mere failure to perceive or avoid a risk because of a lack of due care does not constitute reckless conduct. One must recognize the risk of the conduct and proceed with heedless indifference to that risk. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or certain circumstances may exist. So if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of violating a protection order or consent agreement, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of violating a protection order, then your verdict must be not guilty according to your findings. Now, if and only if you have found the defendant guilty of any of the offenses as charged in counts 1 through 4, you will then determine whether the defendant was or was not previously convicted of violating a protection order in the Highland County Common Police Court, case number 20 CR 0220. And if you find the defendant not guilty of violating a protection order in any of the counts, you will not make any additional finding on that issue as to that count. So the charges set forth in each county indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged according to your findings. All right, so that completes the substantive instructions of the court, and then after we hear closing arguments, I'll give you the instructions on deliberation. Since it's now about 11:40, and since the trial's moved along, I want to give the parties a little time to prepare their closing arguments. So we're going to go ahead and take lunch now, and have you come back and let's say at 12:45. When you do report to the jury room, when you deliberate, you will not be able to have your cell phones or any other electronic device by which you can communicate outside the jury room. All communications will have to go through the bailiff. So we'll ask you to put those on the windowsill back there when you do retire, or you can leave them in your vehicle or at home, wherever you want to, but you won't be able to have them with you at that time. During the break, remember all the instructions of the court. You're not to consider the matter and discuss the matter with anyone, including among yourselves. You're not to form any opinion because, again, we haven't heard the closing arguments and the final deliberation instructions. You're not to research or not try to obtain any information outside of the courtroom about anything in the trial, not to read or listen to anything in any media form about the trial. I'll give you 12:45, a little over an hour, and then we'll be back to conclude the trial. So we'll stand at recess.
Please rise.
Let me have those exhibits. Go ahead. Thank you. We're back on record, State versus Allen, W. Shoemaker, jury's present, and we're now ready for closing arguments. Ladies and gentlemen, the parties will each present a closing argument that reflects their views of what the evidence has shown and the law. They are not evidence and are not to be considered as evidence, but are simply to assist you in making your determination. On behalf of the State, Mr. Willie.
Thank you. May it please the Court. Ladies and gentlemen of the jury, I told you when we started today that we would present testimony and evidence necessary to prove that this defendant violated a protection order on 4 separate occasions. He did this when he sent 4 separate letters to his ex-wife, Teresa Shoemaker. We're now at the end of the trial, and we have proven exactly that. The defendant and Teresa Shoemaker were officially divorced in July 2019. Due to continued contact and harassment, Teresa filed for a protection order prohibiting the defendant from having any contact in June of 2023. That protection order was subsequently granted. The defendant was served with a copy of the protection order, and despite being aware of the order and knowing that he was violating the order, this defendant penned 4 letters and mailed them to Teresa all the way up until the day before the protection order was set to expire. These are very simple, straightforward, irrefutable facts of this case. This defendant violated the terms and conditions of the protection order on September 17, 2024, September 30, 2024, May 1, 2025, and June 18, 2025. This is a felony because this defendant has previously been convicted of this crime. As such, I'm asking that you find this defendant guilty of all 4 counts. Thank you.
All right, Mr. Shoemaker, you have the opportunity to make a closing argument on your own behalf.
Ladies and gentlemen of the jury, my basically is this. On these dates, September 17th, September 30th, May 1st of 25, and June 18th of 25 in Highland County. I was not in Highland County. I was in Ashtabula County at Lake Erie Correctional. The letters was written to my kids. Their name was on the outside, their name was on the inside. The only name on the protection order is Teresa's name. Her name was never mentioned. So that's basically all I've got. Thank you very much.
All right, Mr. Willie, Little.
Thank you. As you'll find in your jury instructions, when you go back to deliberate, the jury instructions make it very clear that it is any part of the crime has occurred in Highland County. Those 4 letters were all sent to Highland County, 4328 Newman Road and 4400 Newman Road. They're both in Highland County. That's been proven. I'm sure that during this trial there were things mentioned that weren't fleshed out or left questions in your mind. But be mindful of the judge's instructions. There are often legal reasons why we can or can't share things with you. And as the judge has instructed you, the evidence and testimony to be considered in this case is what you heard from that witness chair and the exhibits that were admitted into evidence. In considering the testimony and evidence, it is important to remember that nothing the defendant said in his questions is evidence, only the answers from the witness chair. Now, the state must prove each and every element of these crimes by proof beyond a reasonable doubt. The elements of this case are as follows and are outlined on page 6 of the jury instructions that you have back there. On or about September 17th, 2024, September 30th, 2024, May 1st, 2025, and June 18th, 2025, and in Highland County, the defendant recklessly violated a protection order or consent agreement that was issued pursuant to ORC, Ohio Revised Code, 2919.26 or 3113.31. So I'll go through each element and point out the specific evidence and testimony that was presented that proved each element beyond a reasonable doubt. this little chart with all of the elements. Starting with count 1. First, the date. The defendant mailed the first letter on September 17, 2024, per the envelope, which is State's Exhibit 1, which you'll have back there. Teresa received that letter a few days later per her uncontested testimony. The State has proven the date. Next, Highland County. The letter was mailed to a Highland County address per the same envelope. The State has proven the county. Recklessly. The defendant acted recklessly. This defendant knew that sending that letter to Teresa's address was a violation of the protection order. He knew that their children did not live at that address. He acted recklessly as soon as he wrote, addressed, and mailed that letter to Teresa's address. Finally, the defendant was violating the terms of a protection order that was issued pursuant to ORC 3113.31. Simply looking at State's Exhibit 5, which is the certified copy of the protection order, will demonstrate that this was issued pursuant to ORC 3113.31. You heard from Deputy Porter as to what type of contact is prohibited. Among the list that he provided, specifically the protection order states that this defendant may not send mail to Teresa's residence. Just looking at the envelope proves this element beyond a reasonable doubt. We did not hear much about the contents of the letters. That is because the content makes no difference. These could have been birthday cards or Christmas cards. However, the protection order specifically prohibits any contact. Protection order that you will have with you when you deliberate clearly and emphatically prohibits any contact, even by mail and even through a third party. That element is met. The State also must prove that the defendant was served by a law enforcement officer with a copy of the protection order. We know that there's a protection order. That element is met. The exhibits admitted into evidence prove that service was also completed. State's Exhibit 6, which you'll have in the jury room, includes a return of service and says that it was served on this defendant, Alan Shoemaker, on July 7, 2023, by a Deputy Sheriff, Brian Bingham. That element is met. The State has proven each element of the crime beyond a reasonable doubt. Additionally, the State has proven that the defendant has been previously convicted of this crime. State's Exhibit 7, which you'll have back there, is a certified copy of the prior conviction of ORC 2919.27, violating a protection order. This defendant has previously been convicted of this crime, and you need to make that finding on the verdict form. This element is met. Thus, this defendant is guilty of count 1. Now let's go to count 2. Here, the defendant mailed the second letter on September 30th, 2024. Per the envelope, which is State's Exhibit 2, you'll have that. Teresa received the letter a few days later per her uncontested testimony. The State has proven the date. Next, Highland County. The letter was mailed to a Highland County address per the same envelope. The State has proven the county. The defendant acted recklessly. This defendant knew that sending that letter to Teresa's address was a violation of the protection order. He knew that their children did not live at that address. He acted recklessly as soon as he wrote, addressed, and mailed that letter to Teresa's address. We've already discussed that sending mail to Teresa's residence is a violation of the protection order. That element is proven beyond a reasonable doubt. We've also already proven that there was a CPO in place. That element is met, as well as service of that CPO on the defendant. That element is met. The State has proven each element of the crime beyond a reasonable doubt. Additionally, the State has proven that the defendant has previously been convicted of this crime. Thus, the defendant is guilty of count 2. Now on to count 3. Here, the defendant mailed the third letter on May 1st, 2025, per the envelope, State's Exhibit 3, which you'll have. Teresa received the letter a few days later per her uncontested testimony. The State has proven the date. Next, Highland County. The letter was mailed to a Highland County address per the same envelope. The State has proven the county. The defendant acted recklessly. You already heard uncontested testimony from Teresa that the address of this letter, this is the 4400 Newman Road address one. that the address of this letter was one where she and this defendant had previously resided. It is obvious that it was his intention for this letter to end up at Teresa's residence. It is also clear from the language in the letter that it was intended for Teresa. The letter talked about two women named Angie Roush and Teresa Rhodes. Ms. Shoemaker testified that there is no connection between these two women and her children. Teresa also testified that there are no other shoemakers living on Newman Road and that the 4400 address is vacant. This defendant knew that sending that letter to a neighboring address would end up being delivered to Teresa. This defendant knew that this was a violation of the protection order. He knew that their children did not live at that address. Thus, he acted recklessly as soon as he wrote, addressed, and mailed this letter. We have already discussed that sending mail to Teresa's residence is a violation of the protection order. That element is proven beyond a reasonable doubt. We've gone over the CPO and service already too. Both of those elements are met. The state has once again proven each element of the crime beyond a reasonable doubt. Additionally, the state has proven that this defendant has been previously convicted of this crime. This is clear by looking at State's Exhibit 7, which you'll have. Thus, the defendant is guilty of count 3. Finally, let's go to count 4. Here, the defendant mailed the fourth letter the day before the protection order was set to expire, June 18, 2025, per the envelope, State's Exhibit 4, which you will have. Teresa received the letter a few days later per her uncontested testimony. Thus, the state has proven the date. Next, Highland County. The letter was mailed to a Highland County address per the same envelope. The state has proven the county. The defendant acted recklessly. Teresa testified that this address was her previous residence. We've already went over that. It is obvious that it was this defendant's intention for this letter to end up at Teresa's residence. It is obvious that it is clear from what he wrote in the letter that it was intended for Teresa as well. In the letter, this defendant references vehicles bought by the corporation. Teresa testified that the corporation was some LLC that he formed while the two of them were married, but that the children were still minors at the time. Further in the letter, this defendant instructed Teresa to give Ms. Collins Dr. Drew's information. Teresa testified that the Dr. Drew this defendant wrote about was a doctor that she had previously seen, and that this defendant was aware of this. Teresa testified that there are no other shoemakers living on the Newman Road and that the 4400 address is vacant. This defendant knew that sending that letter to a neighboring address would end up being delivered to Teresa. This defendant knew that this was a violation of the protection order. He knew that their children did not live at this address. Thus, he acted recklessly as soon as he wrote, addressed, and mailed this letter. Both of those elements are met. We've discussed the CPO. You have a copy of it. It's there. We've also discussed service of the CPO. Proven beyond a reasonable doubt. The state has once again proven each element of the crime beyond a reasonable doubt. Additionally, the state has proven that the defendant has been previously convicted of the crime. Thus, this defendant is guilty of count 4. The state must prove each and every element of the crimes charged beyond a reasonable doubt. Now, reasonable doubt is doubt based on reason and common sense. This is the same kind of decision-making you use in your daily lives. For example, buying a car. You shop around and collect the evidence. You want a blue SUV, and you find one. The odometer says it has 50,000 miles on it, and it's cold outside, so you need heated seats. It's got it. And the payments will be about $250 a month. Your budget allows for a payment of $350 per month. This is everything you want in a car. All the evidence points to you buying the car, and you decide this is the car to buy. Now, there is some remote possible doubt that this isn't the perfect SUV for you. But reasonable doubt, doubt based on reason and common sense, has been overcome, and of course you buy the car. It is not your job to look for reasonable doubt. If it exists, it will present itself to you from the evidence. In this case, reasonable doubt, doubt based on reason and common sense, has been overcome, and the state has proven each crime beyond a reasonable doubt. Ladies and gentlemen, this case is not difficult. The facts are not complicated. The testimony is straightforward. The exhibits prove each element of the crimes. This defendant was served with a copy of the protection order, and despite that, he mailed 4 letters to Teresa Shoemaker. This is a direct violation of the same protection order he was served with. He has previously been convicted of the same exact crime, which elevates it to a felony. Don't try to make this case difficult. It really is that easy. And simply put, the only verdict that makes sense is guilty. Thank you.
All right. Ladies and gentlemen, you've heard the closing arguments. Again, I'll remind you those are not evidence. They're simply the views of each party as to which the evidence is shown in the law, how the law applies. Now, one thing I didn't tell you when I instructed you before lunch is you are going to have a copy of the instructions for you to refer to if you need to, because I know for most of you, a lot of you it's your first time, you're not trained in the law, and so we make sure that you have those so you can refer to them. Now, I'll instruct you on how to conduct your deliberations and return a verdict once you reach them. You're to be uninfluenced by any consideration of sympathy or prejudice. It's your duty to carefully weigh all of the evidence and decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense to make findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so the state defendant will feel that their case was fairly and impartially tried. Now, if during the course of the trial the court said or done anything you consider to be an indication of my view of the facts or the case in general, you're instructed to disregard it, because that's not the intent at all. I simply make the rulings that the law requires. Now, your first initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide that you may be or are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. That person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater influence than anyone else's. Foreperson is to serve the purpose of helping you to conduct your deliberation in an orderly manner and to give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see that the verdict forms and exhibits and copies of the instructions are returned to the court after you've reached a verdict. As I said, you're going to have these exhibits in verdict forms in your possession, and the foreperson will have control of those. I will point out that on Exhibit 5, which is a certified copy of the protection order, that there are some matters there that are redacted out, and that's because those involve certain findings that were relevant in that case but are not relevant in this case, and that's why those are active. And also to clear up any possible confusion, the statute we're talking about here in the charge is violating a protection order or consent agreement. And that's the title, and that's the way it is, so that's why we have to tell you that. But there is no consent agreement involved, so don't think about that. Those are two different things that apply under the same statute if you violate either. A consent agreement, as it implies, essentially is where the parties agree that they will not do certain things and carries the same penalties if they. But it's an order of the court that's adopted because the parties agreed. In this case, this is strictly a protection order, so don't be confused by the inclusion of the word consent agreement. Now, until your verdicts are announced in open court, not to disclose to anyone the status of your deliberations or the nature of your verdict. Now, this being a criminal case, before it can be said that you have reached a verdict on any count, it is necessary for all 12, I'll repeat, all 12 of the jurors to agree upon a verdict. You will have in the jury room 4 verdict forms. And I'll just read count 1. They're all the same except different counts, 1 through 4. But each of them have the name of the case, State of Ohio versus Alan W. Shoemaker, the case number, verdict, and we'll have count 1. In this case, I'm looking at violated protection order consent agreement, the statute. And then it reads that we, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, and there's a blank space there, and underneath it reminds you to insert there either guilty or not guilty, according to your finding as that count. And it goes on to say a violated protection order or consent agreement as he stands charged in count 1 of the indictment. And as I told you earlier, and it says here in the verdict form, that if you find the defendant guilty of any one or more of the offenses, then in that case you'll also go on to determine whether or not he was previously convicted of violating a protection order or consent agreement as alleged in each count of the indictment. And on there, that's below there, and you will circle which it says was or was not. So you'll either circle the one you find or strike out the one you don't find, so it will be read according to your finding. Now, once all 12 of you agreed on a verdict, you'll each sign on each count. You will each sign your name in ink on each count. Because, again, it requires all 12 of you to agree on the verdict or you don't have the verdict. And your signature on the verdict form is your indication that that is your verdict as to that form. Now, once you retire to deliberate, you'll be under the charge of the bailiffs, and one will be stationed outside the door of the jury room. Ensure your deliberations are not disturbed. As I indicated before on your way in, put your cell phones in the windowsill there if you still have it, and then they'll be returned to you at the end of your deliberations. The function of the bailiff is to ensure your deliberations are not disturbed. However, they cannot talk with you about the case or answer any questions. If you have any questions or other needs, write them down, knock on the door, give it to the bailiff, and then I'll review it after the court has consulted with the parties. I'll respond in writing. Now, I can't promise you I can answer the question you ask, but I'll answer. I will give you a response. And so, for instance, what often happens is a jury will ask me to answer a question about a fact that was not brought up in the case. And so they'll ask me, okay, well, let's say just pull out something, what color of clothing was the person wearing at the time of this matter? Well, if there wasn't any testimony about it, I can't tell you. Number one, I wouldn't know. But even if I did, I couldn't tell you because it's not in evidence. So you can't ask me to give you something that's not in the record. And if you have a question about the law, most likely what I'll do is point out the specific part of the jury instruction that would answer that for you. And if that doesn't answer it, then I can sometimes give you a supplemental response. Now, I want to thank you for your patience, cooperation, and attentiveness, and again, on this really cold day. You've been very attentive, and obviously the parties haven't wasted your time. It's gone very expeditiously, although each were given an opportunity to present their cases fully. All right, is there anything further from counsel? Mr. Shoemaker? No. All right. Then at this time, Mr. Kip Shoemaker and Mr. Curie, as alternates, since nothing has happened that's required one of the 12 to be unable to participate, you will not be participating. Now, when you leave, we'll have you give your cell phone number to the bailiff, and the purpose of that is this. You're not released from your obligations yet. It is possible you could be brought back if something happens during the deliberations where 1 or 2 jurors are unable to continue. Then we would bring you back in, and you would take their places, and then the deliberations would start again. And I've had it happen twice in 17 years, so it's basically insurance, but it doesn't happen often, but it does happen. So until that, and the bailiff will call you and let you know when the verdict has been returned so that you're released from your obligation. At that time, then, you may do whatever. You can do anything I told you could do, okay? That's when you can do that. All right. So if you would just come on around here, and then the jury will retire to the jury room. If you have anything in the jury room, if you would get it out first, please. And you also see Mr. Hodson for your pay voucher. and work excuse if you need one. All right, ladies and gentlemen, you can retire to the jury room. Leave your phones on the windowsill, please. Thank you.
Please rise. You get more of your pizza? Okay, you see me.
He's not allowed.
Judges can only run for office until they're 72 years old. So he's a good job.
Make sure it's in the. You'll make sure they use.
Yes, he's more liberal. Yeah, 115. Okay, let's go. The jury deliberates, we don't stay in here for that. We go back to my office. Then he'll send me a text message when the jury comes back.
All right, I've received a question from the jury. Can you verify that Teresa Shoemaker lived at 4328 Newman Road during the entire time in question? My response is I'm not permitted to answer questions regarding the evidence in the trial. So, take that back to the jury. Thank you.
Please rise.
right, court's been informed by the bailiff that the jury has reached a verdict. Mr. Reno, if you would bring the jury back in, please. Be seated. Be seated, please. All right. The court's been informed that the jury has reached a verdict, and Mr. Link, you're the foreperson. If you would hand those to the clerk, please. You need to exhibit. Yeah. Thank you. Hodson, if you would read the verdict, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25-CR-124. Verdict, count 1, violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 1 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in the count 1 of the indictment. The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25-CR-124. Verdict, count 2. Violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 4 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in count 2 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25-CR-124. Verdict. Count 3. Violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 4 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in count 3 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25-CR-124. Verdict, count 4, violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 4 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in count 4 of the indictment.
Thank you, Mr. Hodson. All right, the court will note that all 4 verdicts are signed by all 12 jurors. And ladies and gentlemen, the jury, are these your verdicts on each and every count? I'll say yea. All right. Anything further from the state?
No,
All right. Mr. Shoemaker? No. All right, then, ladies and gentlemen, well, first of all, the court will accept the findings of the jury and enter findings of guilty on each of the 4 counts as set forth in the verdict forms. Now, ladies and gentlemen, that'll complete your service. I want to thank you for your service. Even though it's a short trial, all trials are important, and it's obviously took some time to look at everything carefully before you make your verdicts, and certainly appreciate that in your service to your community. And as I said, you'll be excused for the rest of this term. Now, that's one thing I've learned in my years, the last 40 years, is that computers aren't perfect. And so if we do happen to send you another notice this term, call us up and just say, hey, I was on a case in January. But you should not get another notice this year or next year. You're exempt by law for another year following from state courts, not for federal court, but from state courts. So you shouldn't get a notice next year either. But if you do, call us and let us know. We've only had that happen once, and it's when they did one of those, those improvements to fixing something that wasn't broke, and always causes problems. All right, ladies and gentlemen, thank you. Enjoy the rest of the day. You can go get your phones and your coats in the jury room. And I'm going to step off, and if everybody would remain, please. All right, we're back on record. The jury is now left. The court has accepted the verdicts and enters finding them guilty on all 4 counts. And given Mr. Shoemaker's extensive history with the court and the nature of the offenses, the court's going to go ahead and proceed with sentencing forthwith. The court will note that Mr. Shoemaker is present. Teresa Shoemaker is present. All right. Anything from the state regarding sentencing?
Your Honor, we would ask for 4 consecutive sentences as these are 4 separate events.
Does Ms. Shoemaker wish to speak?
No, Your Honor.
All right, Mr. Shoemaker, is there anything you would like to say on your own behalf?
No, sir.
Mr. Shoemaker, a friend of mine used to, when I do something that seemed to be not very smart, would say, you know, boy, you're a slow learner. And I think that saying applies here, because this has been going on since 2019. And you've been in prison and in trouble because of 2 things: pen and paper. Yeah. The only person I know that seems determined to stay in prison because you've been convicted over and over again. 2019, violated protection order. 2019, breaking and entering, I think that started out maybe as burglary. And then also menacing by stalking and violated protection order, so that's 2 violations. Failure to appear in 2019. 2020, violating protection order, there's 3. 2023, violating protection order, there's 4. All of these because you're writing and sending stuff to your ex-wife. There's just no reason for that. You have no reason to communicate with her. You know that your kids don't live with her, but you continue to send her stuff. You want to try to stay in her mind. I understand that you have deeply founded religious beliefs, but that's no excuse for violating the law. If you want to look at yourself in the eyes of God as still married to this woman, that's fine. But you cannot conduct yourself in that way in the world because you're divorced. And I know in the last report from the mental health evaluation, they said you finally admitted that in the eyes of the law you're divorced. So why would you want to send something to her? Why? There's just no reason. There is no reason at all except you want to continue to harass this woman and to keep her upset.
It's not harassment.
Well, you continue to do it. There's no other reason. You have no legitimate reason.
The Bible tells me I should. It tells
No,
me
the Bible doesn't. God doesn't tell you to violate the law and harass your ex-wife.
It says to be a watchman.
And you have no right to do that. And there's no doubt in my mind that the only thing that's going to stop you is death. And so it requires for her protection. Because quite honestly, one of my concerns has been over the last, because it's been going on for so long, is that you might finally get smart, quit doing it so you can get out. And then, my concern would be that you would cause her physical harm. But you continue to write letters, and you'll probably continue to do so because you can't stop yourself, or you won't stop yourself. So the only thing I can do to protect her is to make sure that you stay in custody as long as possible for these violations. Your continued activity and committing these crimes justifies the maximum sentence. If there was ever a justification for it, it's this case. And also the court finds that because of your previous conviction for menacing by stalking, which is an offense of violence, that was in 2019, this is not a TCAP case, which would require the time to be served in the county jail. So in this time is to be served in prison. So it is the judgment and order of the court that you be and are hereby sentenced on each of the 4 counts to the maximum term of 12 months. Now, as the court has indicated, this is with these 4 convictions, that brings your total 8 convictions for violating protection order, plus a felony B&E, plus a felony menacing by stalking, plus a failure to appear. And so your criminal history demonstrates that it's necessary to impose a consecutive sentence to protect the public, and in particular, your victim, Ms. Shoemaker. The court also finds this a course of continuing conduct. It was over a period of a number of months, from September to May, so for June, so actually about 9 months. And it was, and again, in this view, and with your record and the nature of your continued violating the law, 1 single prison term is not adequate to reflect the seriousness of your conduct. And the harm is so great because, again, this woman just wants to live in peace, and you won't let her. You won't let her. No matter what you believe under your view of God's word, does that justify harming her and ruining her, continuing to harass her? No. If you want to live in your belief, you're still married in the eyes of God, that's fine. Just don't say anything to her about it. Leave her alone. Don't act like it. Don't take any action in that regard. But no, you continue to do that. And so your harm has been going on against this woman now since at least 2019, if not before, because whatever resulted in the protection order in 2019 would have required events that are not part of this case. But so clearly, the harm you're causing to her is so great that one single prison term is not adequate, which is a reason for that, as well as I said, your history of criminal conduct demonstrating that it's necessary to protect the public, and particularly Mr. Shoemaker from further future crime. The court also finds that it's necessary to deter you from committing future crime and to punish you, because obviously the past sentences, and some of them were minimum sentences, some of them were mid-range sentences. It hasn't worked, and so the danger that you pose to her and even potentially the public is such that again, a consecutive sentence under 29.14C4 is necessary for that purpose. Now, according to the sheriff, came back into the county on November the 3rd, and so that would be 84 days of jail time credit as of today. Now, this is an optional PRC case, and it ought to be mandatory, but it's not. It's an F5. So, upon completion of your prison term and your release, if that ever happens, I don't know. Again, I'm not optimistic. It won't be my problem because I'll be long retired. But in any event, if you do get released from custody in the future, it is possible the Adult Parole Authority would put you under post-release control supervision. I certainly hope that they do. But again, that'll be up to them. It could be for a maximum of 2 years. That means you'll be supervised under the terms they set by a parole officer, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge can impose in that case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court cost for which judgment granted and execution is ordered, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, it could be referred to collections, and they could charge an additional 30% over what you owe. And if that doesn't collect it, if you should be released from prison in the future, then you could be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked would reduce your judgment by that amount until paid in full. Now, you are entitled to file an appeal of the verdict and sentence and finding of guilt by the court. That appeal must be filed within 30 days of the filing of your entry of confinement, which will probably be today. You have the right to have the paper from the case as well as the copy or transcript of the proceedings in order to pursue that appeal. And if you don't have the money to pay for that, the court will provide those at no cost. You're also entitled to have an attorney to represent you. You had the right to have one here, and you didn't exercise it, and it didn't turn out well, which is not surprising. Although, I'll be honest, I don't know that an attorney could have done anything for you anyway. I will give you this. I think you were polite and reasonable, not argumentative at all, and so I'll give you credit for that. But again, if you wish to pursue an appeal, I would strongly urge you to consider asking for an attorney, because you are still entitled to one on your appeal, even though you waived that right for this trial. And so if you do, you'll need to fill out, if you want an attorney, you'll need to fill out a request for that, and then the court will appoint one for you. But again, you must perfect your appeal within 30 days and file a request for the transcript and the records, as well as a request for counsel if you decide you want that. All right, is there anything further from counsel?
No, Your Honor.
Do you have anything else, Mr. Shoemaker?
No, sir.
All right, you're remanded to custody.
Judge, do you want him to sign this?
No.
Yeah, of course, Your Honor.